Hi everyone, welcome to Impact Academy. I'm Yashasvi Chintada. So today let us continue with the polity questions. Okay. So last time we started with some of these questions. Okay, and we have completed till uh, fourth question here. Okay, in the first part. Now let us continue with the fifth question. So in the context of polity, which one of the following would you accept as the most appropriate definition of liberty? So he's talking about liberty, and the options are protection against the tyranny of political leaders, absence of restraint, opportunity to do whatever one likes, and opportunity to develop oneself fully. So when you're talking about liberty, most of you may look at option C, okay, opportunity to do whatever one likes, but that is not the right option because if everyone does whatever they like, then it will become anarchy. Okay, there won't be any order in the state. And absence of restraint is also not true because even in the fundamental rights, if you look at the subparts, there are a lot of restraints. Okay, protection against tyranny of political leaders. Those are fundamental rights and all are there majorly to protect the citizen against the state. That is fine. But liberty is not just protection against the tyranny of political leaders. Liberty is an opportunity to develop oneself fully. So try to understand this question. So these questions are not your questions based on what you say simple subject based questions, right? So most of you who would have read the theory part once will find these questions very difficult. But these are the previous year questions of various competitive exams. So we will look at one-liners also. We will look at the easy questions based on theory. All those things we will. But let us first try to finish the tough questions. Once we finish the tough questions, then going through the easy questions will be very easy. Anyway, so it is the opportunity to develop oneself fully. So that is the meaning of liberty, not just doing whatever you want to do within the restraints, within the constraints. Okay, one should have the opportunity to develop oneself fully. There should not be any discrimination, etc., from the state or from anyone. That is liberty. Anyway, so look at the sixth question. With reference to the Constitution of India, prohibitions or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. So let us look at Article 142. Okay. So what does Article 142 say? Okay. Okay, fine. Let us go to 142. So 143 is also very important. Power of President to consult Supreme Court. So if the president has any doubts regarding any what you say international relations or anything, maybe any treaties signed before independence or anything, the president has the power to consult the Supreme Court for advice. And the advice given by the Supreme Court is only advisory in nature. That is, it is not binding on the president. So Article 143 is also very important. And look at Article 142. Okay, enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. So, Article 142 is giving extraordinary powers to Supreme Court for enforcement of decrees and orders. So, this is what makes the Supreme Court very powerful in our country. Okay, in general, the judiciary, because they can give orders and decrees, and with extraordinary powers, they can even see that those orders and decrees are enforced. So, what he is talking about, Article 152. Okay, he's saying about the Supreme Court of India is not constrained in the exercise of its powers by laws made by the Parliament. So, if you look at previously also, if you look at what do you say the this thing schedules. So, let us look at the schedules. You will get a better idea. So, previously there were only 8 schedules. Okay, this is the first schedule, second schedule, third, fourth, fifth, sixth, seventh. Okay, just go through all this. Very important. Okay, seventh schedule is regarding division of powers. Okay, eighth schedule is regarding languages. So there were only 8 schedules. Later, ninth schedule was added. Why it was added? In order to whatever laws that were made by the parliament regarding the what you say Jamindari laws or abolition of Jamindari and the land reforms, etc. All those things. They, because at that time right to property was a fundamental right. So in order to provide for reforms, if you, for example, if the government takes land of a person, he is going to court saying it is my fundamental right to property. So in order to avoid all those things, most of they've started the ninth schedule, okay, through the first amendment act of 1951. So immediately after the constitution came into being, this is the first amendment 1951. Ninth schedule was made, and all the laws were put in ninth schedule, and they said they are beyond the purview of the judiciary. Okay, they are excluded from judicial scrutiny. But judicial review is the basic structure of the constitution. So what the Supreme Court has ruled is any laws included in this after April 24th, 1973 are open to judicial review. Okay, so basically always the parliament tries to curtail the powers of the judiciary. Okay, they try because they have the powers to actually make the laws. But that does not mean that the judiciary is what you say constrained. Okay, the judiciary under Article 142 has extraordinary powers. So under Article 142, the Supreme Court is not constrained in exercise of its powers by laws made by the Parliament. So even if Parliament makes any laws curtailing the powers of judiciary, using 142, the Supreme Court can enforce all its decrees and orders. So try to remember this option. So which one of the following reflects the most appropriate relationship between law and liberty? So we have already seen, right? What is liberty? Liberty is the what you say the opportunity for the individual to develop himself completely from all fields of life. So if you look at, if there are no laws, then there is no liberty. Okay, doesn't, if there are more laws, there is no rule that there should be less liberty. If there is liberty, laws have to be made by people. It's not possible. Nowhere people make the laws. It's the elected governments or monarchical governments, whatever, they make the law. If laws are changed too often, liberty is in danger. No, all laws have to adapt according to the situation. So if there are no laws, then there will be no liberty. Because there are no laws, everybody will do whatever they want. Then the marginalized sections, etc., okay, people from the minority, people from poor background, especially, they will lose liberty. So if there are no laws, there is no liberty. This is the option. Now see the importance of doing these questions. No matter how much theory you read, unless you do these questions and try to repeat them multiple times, you will not be able to attempt such a question in the exam. And today the trend is to give toughest questions. Okay, so go through the theory part, go through all the articles, schedules, everything which you do regularly, but don't neglect these questions. Okay, they are tough, yes, but they will help you. So consider the following statements. Parliament of India can place a particular law in the ninth schedule. Just now we have seen, right? So ninth schedule, you have to remember all these things. First Amendment Act 1951. Okay. In 2007, Supreme Court ruled that any laws included in the schedule after April 24, 1973 are now open to judicial review. And originally there were 13. Now there are 282. All these are very important because statement based questions can be asked. So the Parliament can place a particular law in the ninth schedule of the Constitution. Okay. And the validity of law placed in ninth schedule cannot be examined by court. So we have just now seen, right? Any law placed after 1973, April 24, 1973, is open to judicial review. So two is wrong, one is correct. So the option is A only, one only. Okay, important question. Now, which one of the following objectives is not embodied in the preamble to the Constitution of India? So let us look at the preamble. Okay, preamble is here. We the people of India. Preamble is very important. Questions are often asked on preamble. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. Very important. So sovereign, what you say, democratic, and republic were there even before the 47th Amendment Act, when the preamble was first written. All these three are there: sovereign, democratic, and republic. Okay, and three words: socialist, secular, and integrity. Okay, integrity were added later on. All this is very important. They are added through the 42nd Amendment Act of 1976. So all this is very, very, very important. And it is talking about justice of social, economic, and political justice, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of individual and the unity and integrity of the nation. And also remember this date, 26th day of November, okay, not January, 26th day of November 1949, where adopt, enact, and due to observe this constitution. It's all very important. Individual statements can be taken and put in a statement form. You have to identify. So read this multiple times. Starting about justice, liberty, equality, and fraternity. Okay, let us see. Liberty of thought, expression, and belief, faith, and worship. So liberty of thought is correct. Liberty of expression is correct. Okay, liberty of belief is correct. But there is no such thing as economic liberty. Right? We have just seen. So economic liberty is the wrong option. Democracy's superior virtue lies in the fact that it calls into activity. Now, if you understand what is democracy, the people are electing leaders who will go and make laws. That means the people are expected to be of sufficient intelligence and of good character. Okay, so that they will elect the right kind of people. So option A is the answer. Democracy means for the people, by the people. So the intelligence and character of the ordinary men and women, okay, is taken into consideration in democracy. Fine. So look at the 11th question. The main advantage of the parliamentary form of government. So if you look at the salient features of the Indian Constitution, there you will see that we have chosen for the parliamentary form. Now, why did we choose parliamentary form? Because the executive remains responsible to the legislator. In the American presidential form, the executive is not responsible to the legislator. The president is not responsible to the Senate. It's the Congress that is responsible for the Senate. Here, here in India, the parliamentary form of government, the executive is almost, I mean, the head of the executive is equal to the legislature, right? When we're talking about the executive, we're talking about prime minister, chief minister, ministers, and all other government officers. And who is the legislator? Again, the ministers, okay? The MLAs, MPs, MLCs, all they are only the legislature. Okay, the government officers will not be there in legislature. But if you talk about the executive, the same minister who is coming and sitting in the office and signing on the official documents, he becomes part of the executive. Okay, and also in this point, remember one important thing: separation of powers. Frequently asked question. So let us look at Article 51. Okay, Article 50. Sorry. See, starting from first article to, you can say, fundamental duties, maybe 51A. You have to remember all the articles. Okay, especially if you are preparing for group 2 also, you have to literally have to remember all these articles, including some of the important subparts. And apart from that, you need to remember 395 articles, and I'm not joking, literally 395. At least out of the 395, you have to remember 100 to 150 articles. There is no other option, because it will be asked in the exam, and that is group 2. You have to go to that level of depth. Anyway, article, that's the reason I keep looking at the articles whenever there is an option. Okay. So try to remember Article 50, all these articles 1 to 51 here are very important. So what is Article 50? Separation of judiciary from the executive. That is very important. So in this question, we are talking about the executive remains responsible to the legislature. Okay, let us look at the 12th question. The mind of the makers of the Constitution of India is reflected in which of the following? So the answer is the preamble. See, the preamble does not contain anything specific, like it does not talk about rights or principles, etc., not duties. So it is just like a preface to the Constitution. So the mind of the makers of the Constitution is reflected in the preamble. So one of the implications of equality in the society is absence of privileges. See, if there are restraints, should be there. If there is no restraint at all, then the whole system will go into anarchy. Competition is very important. Healthy competition is very important for the growth of the society and the business. Ideology also everybody should have. Okay, but there should not be privileges. Whether you are born rich or poor or from a influential family, you should have access to all the basic things and everything, equal opportunities, equal laws, rights, everything. So, absence of privileges. So, look at the 14th question. Which one of the following statements is correct? So, what are fundamental rights? So, fundamental rights are claims of the citizens against the state. C. So try to understand this. Directive principles are the guidelines to the state. It is saying provide equal opportunities, provide maternity benefit, provide what you say, prohibit intoxicated drinks, etc. So it is giving guidelines. But what are fundamental rights? Fundamental rights are giving powers to the citizen against the state. So they are limiting in nature. Remember, they are limiting the states. See, the state says you cannot go for a protest. That is what every state would like, right? Any power, any party that is in power does not want its citizens to go on strike. Okay, so, but right to protest is also one of the fundamental rights. Under right, you can say Article 19. Okay, assembly. Look, let us look at some of the fundamental rights. See, Article 19, if you look at protection of certain rights regarding freedom of speech, assembly, okay, movement, association, profession, etc., all that comes under Article 19. Okay, protection of life and personal liberty, Article 21, that is also important. So, rights, fundamental rights are claims of the citizens against the state. So, it is limiting the powers of the state by giving the citizens more power. So, which of the following is not a feature of the Indian federalism? So you have to understand in India, see, name and union territory, formation of new states, etc. And India is what you say a federation of a union of states. Okay, in the United States, the states have come together to what you say they have an agreement among themselves. So that is why it is called as a federation of states. But here in India, the states do not have the right to secede from the union. So even though we have federalism, yes, there is a central government, there is a state government. So that is called federalism. But we have more tendency to be what to say unitary. The union has more powers. What I'm trying to say is, look at this schedules. So if you look at the division of powers, seventh schedule, very important. The list one is union list, list two is state list, and list three is concurrent list. So the union list has 100. Originally 97, but the state list has only 61. So union list contains more important, all the banking, defense, all important things are in union list also, and also concurrent list contains 52 items. And in case of any discrepancy between or any clash between the state government and the central government law, then the central government law will prevail. Okay, so it has complete power over 100 plus 52, and the state government has only 61. So initially 66 was there. Out of 66, 5 items were taken and added to the concurrent list. Those 5 items are education and weights and measures, forests, etc. So all that will come. 5 items will be there. Try to remember that. Anyway, so what is the question? It is saying which one of the following is not a feature of Indian federalism. So in India, there is an independent judiciary. So that is not a feature of federalism because the judiciary is same whether it is the state or the central. The judiciary is independent. Powers have been clearly divided between central and the states. Just now we have seen. Okay, just now we have seen there is a division of powers between the union and the states. Seventh schedule, list 100, previously 97. State list contains 61, previously 66. Concurrent list contains 52. Okay, 5 plus 1 6, 2 minus 1 1. Remember like that. 52, 61. The federating units have been given unequal representation in the Rajya Sabha, which is also true. If you look at the fourth schedule, okay, the fourth schedule deals with the allocation of seats in the Rajya Sabha to the states and the union territories. Very important. You have to remember all the schedules literally by heart. The fourth schedule deals with the allocation of seats in the Rajya Sabha to the states and the union territories, and it is unequal. See, in the United States, every state has what you say, two seats, something like that, equal, whether it is a big state or a small state. But here, based on the number of constituencies, member of legislative assemblies, etc., the Rajya Sabha seats also vary. A state like Uttar Pradesh may have more Rajya Sabha seats than a state like Goa. Okay, so that is why it is the result of an agreement among the federating units. This is wrong. Okay, there is no agreement between the states. It is an indestructible union of states, India. So 15D is the option. So right to vote and to be elected in India is a constitutional right. Okay, right to vote and to be elected is a constitutional right. Okay, if you look at Article 325, let us look at Article 325. Where is it? Okay, 325. Okay, see, starting from this is also important. Part 15. Okay, the parts are also important. Part 15 deals with elections, very important. Part 15 deals with elections, and it is 324 is talking about election commission. Okay, very important. Superintendence, direction, and control of elections to be vested in a election commission. So today also elections are very near. So election commission, Article 324, all these articles will be asked in the exam. So very important. And what does Article 325 say? No person to be ineligible for inclusion in or claim to be included in a special electoral roll on grounds of religion, race, caste, or sex. So only based on religion, race, caste, or sex, you cannot include or remove a person or have a separate role. So Article 325 is very important. So 326, elections to the House of People and to the legislative assemblies. That means Lok Sabha and State Assembly. Okay, is to be on the basis of adult suffrage. That means if you are above 18 years, you get the right to vote. So 327 deals with power of parliament to make provision with respect to elections to legislatures. Okay. 328 power of legislature of a state to make provision with respect to elections to legislature. So 327 is regarding parliament. Okay. And 328 is regarding to assembly. So remember it in a dry way, very important. And 329 says bar to interference by courts in electoral matters. So in electoral matters, courts are not allowed to interfere. Fine. So remember all these things. Elections is very important. 324 talking about election commission. 325 saying that no one can be left out, and the 326 is saying about adult suffrage. Remember that 326, 327 parliament, 328 assembly, 329 dealing about courts. So remember it in a dry way. You have to remember, especially you're preparing for group 2, you have to remember all the articles. So what is the question anyway? Right to vote and to be elected is literally a constitutional right. And which article? Article 325. Article 325 is, you can literally say right to vote. Okay. There is a parliamentary system of government in India because, as I said, it is a responsible government. Lok Sabha is elected directly. Okay, Parliament can amend the constitution. So all these are fine, but they are not what you say exactly parliamentary system. Okay, the Council of Ministers is responsible to the sea. If you don't practice this question, you would not have been able to answer it in the exam because everything is right. Rajya Sabha cannot be dissolved, which is true. Parliament can amend the constitution, which is true. Lok Sabha is elected directly by the people, which is also true. But he's talking about there is a parliamentary system of government in India because Council of Ministers is responsible to the Lok Sabha. This is the main reason. Because we want Council of Ministers to be responsible to the Lok Sabha, we want a responsible government. We have gone for a parliamentary system of government. So see, it becomes such a tough question. Okay, the parliamentary system always ensures a better representation of the people, and we did not copy from the British Constitution just like that. Okay, we could have taken from the American Constitution also, but because in the parliamentary law, I mean parliamentary system, the Council of Ministers is responsible to the Lok Sabha. So that is the reason we have gone for the parliamentary system of government. So very, very, very important. Try to remember the question. So let us continue for a couple of more questions. Let us stop at 20th question. Okay. So which one of the following schedules of the Constitution of India contains provisions regarding anti-defection? Very, very, very important. I'm sure everyone is aware. And we're talking about schedules. Let us go to schedules. So we have seen the schedules sometime back. So there were only 8 schedules in the beginning. The ninth one came. Then because many people are getting elected from one party and jumping to other party, they have introduced the 10th schedule through the 52nd Amendment Act of 1985, also known as Anti-Defection Law. Very, very, very important. They deal with provisions related to disqualification of the members of parliament and state legislatures on the ground of defection. Anyway, anti-defection law, okay, 52nd Amendment 1985, also 10th schedule. All these are very fundamental. And so 10th schedule, anti-defection law, without any hesitation, you have to answer, it is 10th schedule. Now, economic justice as one of the objectives of the Indian Constitution has been provided in. So fundamental rights, no. And the fundamental rights again, no. See, economic justice is one thing, preamble. Where is the preamble? We are talking about there is justice, economical. Justice, social, economic, and political. Okay, social justice, economic, political means giving the reservation. Okay, economic justice also providing bank loans to SHGs, poorer sections, SC, etc. Okay, and BPSPs. So, directive principles of state polity. Okay, so directive principles of state policy are also very important. So, directive principles, let's quickly look through. 36 is definition of state. 37 deals with application of principles contained. Okay, all that is fine. 38 talks about state to secure social order for the promotion of welfare of people, minimize inequalities in income, etc. So, minimize inequalities, all these things. 39 talks about certain principles of policy to be followed, which is right of adequate means of livelihood for all citizens. So, Manrega. Okay. So, if they might ask, Mahatma Gandhi National Rural Employment Guarantee Scheme is for as which article? Article 39. Because right to adequate means of livelihood. And these are directive principles. So, they are just guidelines to the state and not justifiable in a court of law. Equal pay for equal work. Okay. Prevention of concentration of wealth. Preservation of health of workers' children. Opportunities for healthy development. All this fine. So 39, Article 39 deals with adequate means of livelihood and prevention of concentration of wealth, equal pay for equal work, equitable distribution of material resources, all that. 39A promotes equal justice and free legal aid. Okay, very important, remember. So if you go to the court will assign a free lawyer to you. But no one will take, that's a different thing. They will go with expensive lawyer, that's a different thing. But there is a concept of free legal aid which comes from 39A. Okay. So Article 50 is one of the favorite of Gandhiji, organization of village panchayats. Frequently asked question, remember, 40 is organization of village panchayats. 41 again, right to work, education and public assistance. So all these free schemes, okay, all the free schemes are because of Article 41. It's saying public assistance is the duty of the state. So all is Amavadi and if you say PM Kisan, right, so all they come under Article 41. Very important. A question can be asked. 42 is also related to maternity relief, human conditions, okay, women. So which of the articles, following articles are related to women? You can say 42. You can say 39 also. Equal work for men and women. So if I set a question, I will definitely put this question. Which of the following articles are related are for betterment of women? So most people will not keep 39. People will keep 42, but most of them will neglect 39. Okay. So 41, right to work, education and public assistance. We'll just all schemes are 41. So 43 is living wage to promote cottage industries. So this is also Gandhian principle. 40 is village panchayats, 43 is cottage industries. Remember all these things. So 43A is participation of workers in management of industries. Again, Gandhian principle. 43B, promotion of cooperative societies. Again, Gandhian principle. 44, frequently used uniform civil code. And Article 45. Previously, this was related to education of children. After what you say, 86th Amendment Act, okay, and putting Article 21A, okay, that contains 6 to 14 years. So that changed Article 45 into up to 6 years. Early childhood care and education to below age of 6 years is the duty of the guardian or the state. Okay, so 45 is related to education and 21 years 6 to 14 years. Providing the state shall provide education from 6 to 14. So 46, I briefly remember as you can say SC/ST, okay, on weaker sections. No need to remember complete statements because we need to remember all the articles. So 46, immediately you need to get SC/ST minorities. Obviously, the state will try to promote the interest of scheduled caste, tribes, and weaker sections. 47, immediately the thing that comes to my mind is drugs. Okay, let us see. Duty of the state. See, I did not even look at the statement, but what came into my mind is drugs. So that is how I remember. Okay, 47, duty of the state to raise the level of nutrition and standard of living to improve public health. Okay, to prohibit consumption of intoxicating drinks and drugs. Okay, okay. So to prohibit drugs and also to increase the level of nutrition standard of living. 48, agriculture and animal husbandry. Okay, 48 is also Gandhian. 40, village panchayats, and this 43 is Gandhian principles. 48 is also agriculture and animal husbandry. 48A is protection of improvement of environment and safeguarding forests and wildlife. So it has been added later, 48A, right? So forests and wildlife. 49 is protection of monuments and places objects of national importance. So 50 is separation of judiciary from executive. We have already seen just now. 51 is promotion of international peace and security. 51A is fundamental duties. Okay. So we'll look into that when that comes. Okay, that is a separate topic. So which question we are in? 19. So economic justice. So we are talking about preamble and directive principles of state policy. Okay, fundamental rights does not exactly deal with economic justice. The directive principles and also try to look at what articles are providing economic justice. Okay, I would say article economic justice, right? So 39 is there. Okay, right to equal work, equal this thing, and 43 minimum living wage, participation of workers in industries, all these things. Okay, try to remember all these things. So let us look at the last question for today, 20th question. A constitutional government by definition is a, okay, it's a limited government. So constitutional government by definition is a limited government. So what does that mean? Basically, we're talking about the fundamental rights and etc. etc. Okay. The reason for writing the constitution is to limit the powers of the government. So yeah, if a question like this is asked, people will get easily confused. They'll think it's a popular government, okay, or they'll think it's a government by legislature. But a constitutional government, yes, all these are true, okay. But a constitutional government by definition is a limited government. Very very important question. Try to remember these things, because it has limited powers, okay, and it has a lot of responsibilities. So by definition, constitutional government is a limited government. Okay, we'll stop for now. Continue the next class.